Waters O'Doherty Court of Appeal Judgment. I sourced the actual judgment in the O'Doherty Waters appeal, handed down, no ups here, yesterday the 2nd of March, 2021. My own focus on interest in this case was the question of how the High Court hearings had met the requirements of Article 34.1, justice shall be administered in courts established by law by judges appointed in the manner provided by this Constitution, and, save in such special and limited cases as may be prescribed by law, shall be administered in public. In spite of one of the judges in the High Court hearing, I have read it myself in the transcript, determining that the audio recording, DAR, of the hearing was to be given to the applicants and that O'Doherty, as per transcript, made it clear that she would circulate that recording. I, personally, cannot find a copy of that recording anywhere. John Waters did state in a livestream video with O'Doherty that the DAR was on her site, but later resiled from this following my query to him in this regard. As a citizen who, myself, was prevented from attending the court as an observer in order to evaluate the merits of both sides' arguments due to imposed travel restrictions in these COVID times, I sought a copy of the DAR recordings from the court's service directly. I was given the runaround, obfuscation, blockage, bureaucratic treatment, but no access to this information. Reading the court transcript, it is clear that the judge was offering this access to the DAR as part of his attempts to justify the hearing being held in front of, at best, a restricted audience. There was, to my understanding, only one court reporter present, Aidan O'Feolane, a freelance operator. I spoke personally with him. He told me that in 16 years of court reporting he had never personally had access to a DAR, and he exhibited very little appreciation of the central issue of the administration of justice in public in this case. Neither, it appears, did or do Messrs. O'Doherty and Waters appreciate the far more serious at play here in this hearing, that of the public's right of direct access to observing and legitimating the tenet that justice must be done and seen to be done. This DAR audio recording belongs, not to John Waters, or Gemma O'Doherty, or to the judge, or to the court's service. It belongs properly to you and I, the citizens of the Irish Republic, whose taxes pay for the administration of justice. We have morphed into the new paradigm of restricted movement and restricted physical access to the administration of both government and justice. Ask yourself, when is the last time you have heard or seen reference to anyone of the public being in the DAL Public Gallery? What are the negative consequences of limited and restricted Oireachtas sittings in terms of the probative possibilities relating to new legislation? What are the negative consequences for restricted public access to court hearings in future in terms of citizen oversight? These are critical issues for democracy. Sadly, the circus, over-the-top approach by Gemma O'Doherty and John Waters and their specific failure to share the DAR publicly, as O'Doherty stated was her intent, may well have assisted an unintended consequence of furthering the slippery slope of restricted public access to monitor how our society is administered. For the record, my personal belief is that, given the ubiquitous availability of cheap technology for recording, live streaming etc., that every single court hearing, every hearing of public administration, Oireachtas, county councils, etc., should all be live streamed in the public interest. As the post-pandemic paradigm locks in, this protection of the public interest will be better understood. Will it be too late? Do you care? Does it matter? Quote, from article, they had chosen rhetoric over substance and fiction and distortion over fact and failed to meet the threshold of establishing an arguable case, the judge concluded.